Hello everyone, I'm George from Ireland, continuing with my English law channel. So I was looking at land law and formalities when it's being sold and so on. So there are conveyances, and that's when it's actually handed over, and this is quite a tricky matter, and it varies according to whether it's a legal or equitable interest that is being conveyed. So the Law Property Act 1925, if you look at section 52 there, it will say you can create the conveyance, or you can create or conveyance a legal interest in land only by deed. And the Law Property Miscellaneous Provisions Act 1989, section 1, says this must be a signed and witnessed document. So go back to Law Property Act, here and after, I think LPA for short, LPA 1925. When you create or dispose of an equitable interest in land, this must be done by signed writing. Anyway, so there are more things about registered land. In a way, it makes it easier, registered land, because we know actually what's on the land registry, who it belongs to. Now, there are a few exceptions to the foregoing. If there's a legal lease that is very short, I mean, 3 years or under, then it won't be according to the rules outlined herein before. So long as the rent is at a market rate for that lease and a premium is not charged at the beginning, and you could create that orally under the section 54 of the LPA 1925. It's still pretty unusual to do so, because what was actually agreed in this oral treaty might be disputed what the particulars were. Sometimes there's an implied trust of land, not an express trust of land, and in this implied trust of land, it will be exempt from the requirements which I adumbrated earlier. Anyway, there are similar formalities, not exactly the same, similar, that are applicable to express trusts of land. So on the LPA 1925, you have to have signed evidence that express trust of land was declared. The declaration itself might not have been in writing. Usually is in writing, but that's optional. It's the evidence that it has been created must be in writing, not the agreement itself. So coming on to the LPA 1925, section 53.1, any later conveyance of an extant equitable interest, if it's in land or in anything else, is like when you create or dispose of equitable interest in land, something which must be in signed writing. And often they really do mean physically signed, not just online signature, because this is so important. Generally speaking, online signature is acceptable. Okay, so let's go through definitions. Now, there's a lot of terminology to learn here, right, about what property is. We're reading about realty, which is land and buildings thereon. A proprietary interest, as in to do with having that property. Proprietary rights, you're going to hear personal rights, which is for an individual, and it's not the land itself, because sometimes the land, curiously enough, has rights, right? It might be in rem, as in the person. This piece of land, Blackacre, we always call it in pedagogical examples, has certain rights. If I own Blackacre, those rights are usable by me. But if I sell Blackacre, then the purchaser can use the rights because they pertain to Blackacre. Some rights are only personal and they're not passed on at sale. Real property, which is like land and buildings. Realty, we often call it. That's in the United States, they often have realtors or a real estate agent. In the UK, it's just estate agent, not real estate agent. Because property more broadly are any possessions, chattels, movables, your clothes, your laptop, and so forth. Or indeed intellectual property, the rights over a piece of music you've composed, for instance. So we know what land is. It's got to be, which is something which is above the high tide mark, and apart from that, really I don't think it needs a further definition. It's got to be soil, sand, rock, something like that to do with it. The quies et solum rule, as in about whose soil it is. Tenure, as in the right to control this land for a set period, even though that could be centuries. There was a feudal pyramid in the old days, the king at the top, the major landowners just below him, about half a dozen earls, a few dozen barons below that, maybe some knights, and most people down there, tenant farmers and sometimes landless labourers, bourdars, what else they're called, villains. Not to mean they were wicked, but just that just meant a poor peasant. I know it's come to mean like a scoundrel these days. Well, you'll learn about the doctrine of estates, as in the different type of ownership of land you could have. There's corporeal hereditaments, as in to do with something which is physical, and incorporeal hereditaments, things which aren't physical, for example, inheritable title. Chattels, like I said, movable goods. There are fixtures which are buildings or pipelines or something like that on the land, maybe even a canal. Then there's some things which are physical changes of the land which might not be seen as a fixture, like a mound of earth, which can be moved fairly easily. We're going to look at what ownership really is and possession. Note, possession and occupation are not the same in law. You might possess something, yes, legally yours, but don't actually occupy it. Somebody could be occupying it against your wishes. That's adverse possession, a squatter. We'll come on to that later on. Title, as in the right to have this. What was your right to this land? Like there was the Native Title Act, a contentious issue in Australia. Many former British colonies, because the old terra nullius principle, as in nobody's land or empty land, so that the English law regarded Australia as being uninhabited when the first fleet docked at Botany Bay in 1788, that 26th of January. Others say, well, not uninhabited, but just that there was no land ownership. The Aboriginals lived there, but they didn't own a square inch of it. So we've got unregistered title, as in land which is owned, but is not on the land registry, as opposed to a registered title, which is something like 90% of the land in England and Wales. That's rising and rising, probably be 100% in 20 years' time. Fee simple, absolute in possession, which is the highest quality of ownership, because as we'll see, it's immensely tricky. There's several different types of ownership. Term of years absolute, as in yes, you can own it absolutely, but only for a set amount of time. 10 years or 35 years or whatever it might be. An easement, we're going to find these certain rights that people are granted or the public is granted in relation to a piece of land, to walk across it, to park on it, or whatever, to use a lavatory. Mortgages, as in where there's a mortgagee and a mortgagor. The mortgagor is actually the person who's bought the house. The mortgagee is the bank or mortgage company, and So the bank really owns it. The other person has to redeem it. Otherwise, the bank's going to take it away and sell it on. Restrictive covenants, as in only certain people can live here, only if you don't have children or only if you don't have pets or whatever, or agreeing not to do this or that on your land, to plant trees above a certain, they're going to grow too high. Common law and equity, these two systems and this parallelism is going to continue. I know life would be a lot easier if they simply somehow amalgamated them. Equity's darling, remember the purchaser for value, for fee simple, without notice, absolute. So then we got legal estate, as in owning things in law as opposed to in equity, and your legal interest, which arises from law rather than equity. And equitable interests are a little bit different, are less formal. And remember, equity is about righting the wrongs of law's excessive rigidity and harshness. Trust, remember, trusts are created so that the beneficial owner and the legal owner might not be the same person. Trustees are sorting this out. There's a Trust of Land and Appointment of Trustees Act, TLATA I call it, which govern this. The settlor, who creates a settlement, as in to say what's going to happen to his or her property after he or she dies for many generations. An express trust, which is created deliberately, calling it a trust. Implied trust, which is not created in an obvious manner, but it's taken to be that somebody wanted this trust to be created. A trustee, whose job it is to govern the trust, to do whatever the trust is set up to do, as in often to allow the land to be used by the beneficiaries. The beneficiary is the person who's gaining from this. There are also things like trust funds or trustafarians, people from who are independently wealthy families, and say their grandparents would set up some trust to make sure that their grandchildren have a certain amount of money each year. They couldn't go and blow it all in one year. Legal title, that is owning things in law as opposed to in equity. A beneficial interest, as in you have some rights deriving from a piece of land, to live there or to get profits from it or something like that. And there's interest in possession, interest in remainder. Reversionary interest is when it's going to come back to you after a certain period of time. Okay, so I think that's enough at the moment, and some of the terminology of land law. Toodaloo.